I just want to talk to my daughter, Your Honor.
Your Honor.
I don't want to punish my daughter.
Hold on,
Your
Mr.
Right,
Johnson.
Johnson, let me just say this. I revoked your phone privileges because I felt that I had to. You would have been entitled to a hearing and the like. But sometimes, sir, what you got to do is you got to let the process work itself through. And if you keep trying to force things and do things, it's just going to cause you more headache and more problem. Court does call the case. People versus Sean Johnson.
Alexander, on behalf of the people, Your Honor.
We have the amendment.
Alex Warren, great on behalf of Mr. Johnson.
Oh, that's after the call. Okay. All right.
What? With the testimony of a police officer. Just this. Your Honor, today's date and time for preliminary examination. The prosecution just informed me that they are able to proceed and that they were seeking to proceed under the exception laid out in 768.
Hold up. This is a major crossroads in the case. The defense has just learned the prosecution may be able to move forward without the alleged victim testifying at this hearing. That's a huge procedural twist, and it's forcing the defendant to make a high-stakes decision in real time. Would you roll the dice and fight the hearing or take the deal that's being offered?
27C. Relayed that to my client. I do believe my client wishes to waive his right to a preliminary examination today. I was just relayed this information, Your Honor. If the court could accommodate passing this matter, I can better inform my client of what that means.
That's correct, Your Honor. We would be looking to proceed under 27C.
All right. I'll pass it and let you go back and talk to your client.
Thank you, Your Honor.
All right. So,
Complaint.
Yep, I'm not.
They'll bring him out if you're ready.
yeah, I'm ready. I'll do it. Court calls the case of the people of the state of Michigan versus Sean Johnson.
Alexander, on behalf of the people, Your Honor.
Good afternoon, Your Honor. Alex Warren Green on behalf of Mr. Johnson. Your Honor, today's the date and time for preliminary examination. I appreciate the court's accommodation in passing this matter earlier. I did have an opportunity to speak with my client. My client does wish to proceed with examination, knowing that the people do intend to proceed using the exception laid out in MCL 768.27C. And I think he understands that by proceeding, the people would be rescinding their offer of not adding any habitual offender sentencing in exchange for his waiver.
Okay. And sir, that is your decision?
Stand up.
That's your decision?
Yeah, my attorney said that,
Well, I don't want to know what's your discussion.
Witness. Or
Mr. Johnson, when we spoke, I explained to you that there is an exception to the general rule laid out in MCL 768.27C, under which the prosecutor could make a showing and the prosecutor could have a preliminary examination without the presence of the person who directly accused you of this. You understand that, right?
yeah.
Okay, so you understand that if we proceed right now, we are going to have a preliminary examination, right?
But you said in the back if she wasn't here that I would be let go.
Okay, hold on. Because I really don't want your conversations on the record. Why don't I take a break, let you discuss with him in more detail as terms of what he wants to do. So why don't I give you about another 15, 20 minutes and you guys can figure it out. Because I want to make sure he understands what he's doing, particularly since there may be habitual offender charges that could be filed.
Thank you, Your Honor. I really appreciate the court's accommodation.
Or extend in recess.
All right.
Watch how carefully the judge handles this moment. Before a defendant gives up an important
That's
legal
the
right,
case of the
the
people
court
versus
wants
Sean
proof
Johnson.
that the decision is knowing
Alexander,
and
on behalf of the people, Your
voluntary.
Honor.
The judge
And
isn't
Alex
deciding
Warren
guilt
Green on
here.
behalf of
He's
Mr.
making sure
Johnson.
nobody walks into a major legal consequence without understanding exactly what's at stake.
Does call the case of the people versus Sean Johnson.
Alexander, on behalf of the people, Your Honor.
And Alex Warren Green on behalf of Mr. Johnson. Mr. Johnson, can you state your name?
Sean Johnson.
All right. And are we going to have a preliminary examination? Going?
The people are ready to proceed.
And Your Honor, I did have an opportunity to speak with Mr. Johnson at length. I think Mr. Johnson understands people's position. At this time, he does wish to waive his right to a preliminary examination. The people in exchange have agreed not to add any habitual offender sentencing enhancements. Could you sign?
All right. Mr. Johnson, is that correct?
Yes.
I'm sorry, I think you said yes, but your handcuffs hit the,
Yes.
all right. And Mr. Johnson, you understand, I'll let you finish signing there. You understand that a preliminary examination is a proceeding where the people would have to show by the standard of probable cause that the offense alleged was committed and that you committed it. You understand that, sir? Yes?
Yes.
All right. You understand you'll not have that hearing and you'll proceed to circuit court for further resolution of this case. You understand that?
Yes.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr. Warren Green.
Your Honor, we acknowledge receipt of the information, waive its reading, and stand mute.
Defendant having waived former reading, stand mute. Court will enter a not guilty plea. Pre-trial in this matter will be set for
June 26th at 1:30 p.m. with Judge Slay.
June 26, 2025, 1:30 before Judge Slay.
And Your Honor,
Is there anything sooner than that? Please.
Hold on. Because that's, you may be right, because that sounds like an exam help date.
I'm just giving you some willy-nilly. How do you like May 22nd?
We'll get you a quicker day, May 22nd.
Okay.
Thank you, Your Honor.
May 22nd, 2025, 1:30 before Judge.
I just want to talk to my daughter, Your Honor.
and Your Honor,
Hold on a second.
Yes.
I did want to bring to the court's attention, after the defendant's phone privileges were revoked last time, he did try to attempt to make a call with the same number to the victim, but the victim's number was blocked from the jail. I am concerned that he tried to call that number again.
I don't want to punish my daughter.
Hold on,
Your Honor.
Mr. Johnson.
Johnson, let me just say this. I revoked your phone privileges because I felt that I had to. You would have been entitled to a hearing and the like. But sometimes, sir, what you got to do is you got to let the process work itself through. And if you keep trying to force things and do things, it's just going to cause more headache and more problem. I'm not going to take any action on what the people are raising, okay? But I'm going to suggest as this case proceeds toward Judge Slay that you not enter into that behavior.
I just want to talk to my daughter.
I know, but you'll get there, you'll get in a position to do that sooner if you follow the rules that we have now, okay? Bound with its conditions will continue. Thank you.
Thank you, Your Honor.
What is the bond anyway?
It's $50,000 cash. And we can pass that in Judge Slay's court on the 22nd, right? Sean.
Thank you.
Thank you, Your Honor.
I'm sorry I took much time.
No, you didn't, sir.